The Illinois State Police and Director Brian Kelly, who is also here, as Ms. Avalos said, have provided us with every resource we needed, and they have supported this prosecution at every turn. Our victim service specialists, who are also here, have kept hundreds of victims up to date and guided them with compassion and expertise through every court date. Thank you. We are working on this problem. We were right to pass an assault weapon ban in Illinois. State Representative Bob Morgan is behind me, and I thank him as a resident of Highland Park myself for that, as a resident of Illinois. But the work is not yet done. It is our hope that this prosecution has been part of that work. As I mentioned earlier, Catherine, Eduardo, Irina, Kevin, Stephen, Jackie, and Nicholas should all be here. This is not a day to celebrate. It is a day filled with deep emotion for many, but also hope. We hope that by holding this father accountable and by sending him to jail, we are sending a powerful message to others. Reckless decisions like this have consequences, and they are unacceptable. There will be a cost. Justice will have its day. Our hope is that fewer families and fewer communities will ever suffer a tragedy like the Highland Park shooting. I'm happy to take a few questions.
Eric, so you said in court that you spent a lot of yesterday talking to victims.
Yes.
And can you detail what that was like and how they feel about this plea then?
Certainly there were a lot of private conversations. I want to keep those private when it comes to individuals. They were supportive, but obviously are devastated over the loss. Many of them are still dealing with that. Obviously, this case going to trial or planning on going to trial or having a plea today has been difficult for many. They are supportive of this. So many people I talked talked about wanting to send that message that parents cannot do this.
Was this enough for many of them, or were they disappointed?
This was enough for many of them?
Toward the camera?
Sure, I'm sorry. This was enough for many of them. I don't want to characterize individually. Obviously, we talked to many people, many individuals, almost every individual I personally spoke to, and I probably spoke to about 10, maybe even more, want that message sent. They want the message sent across the country that parents must be held responsible for this. Could the beacon be brighter if he was spending 3 years in prison, which was the max? Possibly. But we've still laid down a beacon. We've laid down a marker to other prosecutors, to other police in this country, to other parents, that they must be held accountable. And the risk of potentially losing in this innovative prosecution and not putting down any marker was too great for our trial team. We have said that we will hold parents accountable, that they should be accountable anywhere in this country for any of their reckless decisions, and this individual having the certainty of jail, having the certainty of punishment, and taking responsibility was so valuable, and I think every victim I talked to agreed with that.
Eric, is it part of the plea agreement that Mr. Cremo will testify as a prosecution witness in his son's trial?
No.
Do you expect him to do that?
I'm not going to comment on that, but it's not part of the plea negotiation it's not part of the plea negotiation.
Mr. Gomez suggested when he spoke just a few minutes ago, he said the state is trying to pit members of the family against each other, and that one of the reasons he agreed to a plea deal was to protect his family. Any thoughts about that?
No comment.
Well, when did the plea negotiations start?
No comment. I'm not going to get into that. That's not going to comment on the timing of the plea negotiations.
Can you talk about what makes this case rare and unique, and how you prepared to go to trial, and maybe whether or not a plea deal came up in light of how rare and unique it is?
Yeah, the question was about how rare and unique these prosecutions are. I'm aware of a New York case where I believe it was a misdemeanor criminal endangerment. I'm aware of the Crumley case in Michigan. Those cases are all very different than this case. This case has the time period in it where the void card was applied for in 2019, and obviously the Highland Park shooting happened in July of 2022. That did make this case also unique because of that delay. But any parent who is reckless in these decisions isn't going to have any idea when that ticking time bomb will go off. And so in the Crumley's case, it was a matter of days. In the New York case, I believe it was a matter of weeks. This was a matter of years, and we have held him responsible even over that period of years. He will go to jail, he will be on probation, and he has said he is guilty even with that delay. And if it's a shorter delay, you can imagine even more severe consequences. But any parent or anyone else who is reckless in allowing people access to firearms won't know when that ticking time bomb is going to go off. And frankly, this father didn't either. And it was 2.5 years later, but he was still reckless, and he was criminally reckless the moment he submitted that affidavit.
He has to surrender his Ford car as part of his surrender.
Yes.
What happens to his weapons? Does he get to keep his weapons, or does he have to surrender those as well?
He's also surrendering his weapons.
Eric, what do you say to the survivors, or those who were even there at the parade, who look at this and say, okay, 2 months in jail, it's not enough?
Yeah. Because of the question about this being an innovative prosecution, because of the years, there is not, I have a great deal of respect for the judge. I have a great deal of respect for the judge. He's a good judge. There is not a lot of comps. That's not a great term, but you know what I mean. Because of the uniqueness of it, if the judge found there was a break in the causation over the 2.5 years, there would be no responsibility. And so what I have said to many people who've asked me that question is that this holding a parent responsible and seeing incarceration and probation and even monitoring during that probation and the certainty of that punishment, the certainty of that moral truth, that legal truth now, that you will be responsible, was so important. It was so important.
Eric,
Question for-
Mr. Gomez earlier had suggested that not having the public trial is also in the best interest of the Highland Park community to not relive those events. Would you agree with that characterization?
I think a lot of the people I spoke to were looking forward to a public trial about this. That didn't really enter into our calculations, the public aspect of it. Certainly this brings some closure on how the father should be looked at legally, that we can begin to write the history of the July 4th tragedy. We can begin to set it in concrete. Sometimes that can be hard in our society these days. There are a lot of arguments about contested truths, but every one of you here heard him take responsibility for this. Every one of you here heard him say that he had committed a crime. So we certainly care deeply, and we have amazing victim specialists. We care deeply about the trauma that the Highland Park survivors are going through, but a public trial is part of our country, and we were ready to go forward. We were ready to go forward today.
When you say that some people said they were looking forward to the public trial,
Sure.
Who do you mean by those people? Was that victims? Was that people in the state's attorney's
Lots of
office?
not people in the state's.
Community, like-
The community. I'll say the community, not
Okay.
people in the state's attorney's office, but the community.
Gotcha. Thank you.
If we can ask the state police here, does this plea give you more teeth when it comes to these documents and with doing the background checks that you need?
It does. This sends a very strong message in a way that's unprecedented in the history of our state, and to some extent unprecedented in the United States. To be able to put this case together for this aggressive and innovative, creative prosecution, to be able to move forward and produce accountability where the individual who signed a document holding out that the shooter in the Highland Park case was not a threat and somehow was okay to have a firearm. The message that can bring consequences. You may not be the person pulling the trigger. You may not be the person with the firearm, but you could be held accountable for that conduct. If you have knowledge that someone is a threat and you don't act on that, particularly if you're a family member and you fail to do that, you could be held accountable. You could be looking at jail time yourself. And that is something that we've not had before in this state until this moment today. We've not had that to a great degree in this country. So this is progress. There is nothing that can be done by the justice system ever to replace or completely heal the terrible trauma and wounds of the people that were impacted by the Highland Park shooting. But this is progress. And this does support and does strengthen the notion that if you're signing something and you're going through this process, you're helping someone have access to firearms, or you're selling them firearms, or you're aiding them in getting access to firearms, you can be held accountable too. And that is a very positive development.
Sir, can you say and spell your name and your title?
Sure. Brendan Kelly, Brendan Kelley, Director of the Illinois State Police. Anything else?
I have one more question.
Yes, ma'am.
Looking back though, because there were notifications to the police and to
Yep.
to the Illinois State
Yep.
Police of problems with his son.
Yeah.
Do you look back and regret that things should have been done differently, or is this gonna change the way you go forward?
So I think that if you look at the facts that were stipulated today by both the prosecution and the defense, it lays out very clearly that Highland Park certainly did their due diligence, and they tried the best they could to investigate allegations. Those allegations could not be substantiated. That conduct was disputed. The information that was submitted for a clear and present danger review did not meet the legal threshold, in part because the weapons, the knives that were supposedly in the possession of the Highland Park shooter were later claimed by the father to be his. And so it was his own family members that made it difficult to establish that clear and present danger, and that was part of the facts that were stipulated to by the defense today. Now, there have been many changes in procedures, and the process of continuously tightening and finding what loopholes may exist, unforeseen circumstances that law enforcement or even mental health professionals have not been able to contemplate until something actually occurs. That's an ongoing process of continuous improvement. I cannot say that the changes that have been made subsequent may have impacted the outcome in this particular case. But we know, and we're already seeing the advancements that have been made, the new laws that have been passed, administrative rules that have been in place, the teamwork you're seeing by law enforcement, the huge increase that we've seen by law enforcement and family members reporting these clear and present dangers, that is making a difference. So what has happened here is resulting in changes that are saving lives, and the amount of stories and the close calls and the amount of tragedies in which the system has been able to intervene and prevent subsequent to that, those are real. Those are real improvements. But I think we only would, none of us have a crystal ball, and it's very difficult to say that the changes that have occurred subsequently could have prevented this in the past, in large part because the information that was necessary to be able to establish a clear and present danger was information that the defendant today had knowledge of, not the police.
Other questions?
What is the current status of Cream III's proceedings?
Next court date then? December 11th is the next court date.
Maybe ask Mr. Morgan just for a little bit of broader community reaction.
State Representative Bob Morgan represents Highland Park. Today we are here just to show our gratitude to State's Attorney Reinhardt and his team, who have worked to make sure we have the beginning of justice for what we went through as a community. The conversations I had with the State's Attorney and with those who were direct victims and also those who were traumatized on the 4th of July last year recognize that this is just a small step, but a step towards justice that we are all hoping and praying for. And there are a lot of people that are still traumatized, physically recovering from the trauma of the shooting, of actually being shot. And so our community is looking forward to continuing the work towards justice, but we are here today to thank the State's Attorney and his team.
So just to recap, this weekend, if there are parents out there who may have supported their child getting a FOID card in the past, you're saying a bright line has been drawn today and that they should do what?
Well, the factual basis wasn't. The factual basis was about, it included the things that this defendant knew about his son. One of the things I've been most concerned about in the arguments that I've heard is that for some reason Director Kelly and his team would know more about a child than a parent. I guess that technically could be true if parents are not involved in people's lives, but it wasn't true in this case. It wasn't true in terms of what this father knew. It wasn't true at all. And so this father had a lot of knowledge. He agreed that he had that knowledge in court. We talked about very specific evidence that the father was aware of at the time that he signed the FOID. This has to do with what you know when you sign the FOID. And he knew that information, and he was reckless. It means that there was a risk, that he was aware of that risk, and he went forward anyway. He didn't care. And for that reason, he has now been convicted of a crime.
Eric, one more thing. They said in court, the last court date, they mentioned that one of the things you were going to put up for evidence was that the son said something about doing a mass shooting at a school to a friend, and the friend was going to possibly testify.
Yes.
And today, did father stipulate to that being true?
Yes.
That it was said that he knew about it and minimized it? Is that all-
Yes, he
is that
didn't,
all
he
that-
didn't,
is
the
that
word
all-
minimized, word minimized didn't come up in court, but obviously,
Is that the gist of it?
yes, he agreed, I can't remember which number it is, but in the stipulation that we entered into today,
So in addition to everything else he knew, we also knew that his son threatened a mass shooting?
yes.
To a friend?
Well, it wasn't a friend, it was to a camp counselor.
Oh, camp
And the camp counselor directly reported that, to the father. So it wasn't second or third hand. The counselor hears it, the counselor calls the defendant, the dad comes and picks up the son, and he conveys it to the dad, that type of threat of a mass shooting, yes. They stipulated to that.
The detective want to say anything? Sounds like he played a big role in this.
He did play a big role. I don't think he wants to. It is true. It is true. He did play a big role.
You mentioned, Mr. Snyder, though, wasn't there an allegation of somebody putting a hand to his neck and or a gun, pulling a gun on him?
So earlier in the court appearances, we made the judge asked for what's called an offer of proof. That's where a lawyer gets to say what he or she thinks the evidence will be. Part of that offer of proof was that that Bobby Cremo III made contact with that camp counselor at some point while the camp counselor was describing what Bobby Cremo III had said to the father. Thank you very much. Appreciate everyone's time.